Hello everyone, welcome back to our Learning Legal English through Case Laws series. In this video, we will study case law number 26/2018/AL regarding determination of the commencement of the statute of limitation, and statute of limitation for requesting for division of the estate being real estates. We'll start with the source of the case law, the overview of the case law. Then we'll move to the content of the case, assessment of the court, and finally, the rules from the case. This case law was adopted by the Judicial Council of the Supreme People's Court on October 17, 2018, and promulgated under Decision Number 269/QDCA dated November 6, 2018 of the Chief Justice of the Supreme People's Court. Cassation Decision Number 06/2017/DSGDT dated March 27, 2017 of the Judicial Council of the Supreme People's Court, regarding the case on dispute on inheritance and division of common property in Hanoi. Between the plaintiffs, which include Mr. Kenshin V, Ms. Kentn 1, Ms. Kentn T1, Ms. Kent H, Mr. Kenshin T, Ms. Kentn 2, Ms. Kentm 1. And the defendants, which include Ms. Nguyen T L and Mr. Kenon C. Aside from that, there are 7 people who are persons with related rights and obligations in this case. Next part is the overview of this case law. First, the case law situation. The owner of the estate being real estates had passed away before August 30, 1990 being the issuance date of the Ordinance on Inheritance. At the time of the first instance hearing, the Civil Code 2015 was effective. And the legal resolution for this case is as follows. The commencement of the statute of limitations for requesting for division of the estate must be determined as the issuance date of Ordinance on Inheritance, i.e. August 30, 1990. The determination of the statute of limitation for requesting for division of the estate is subject to the regulations of the Civil Code 2015. The applicable provisions of laws relating to this case are Article 623.1 of the Civil Code 2015 and Article 36.4 of the Ordinance on Inheritance dated August 30, 1990. The key words of the case law include divide estate, statute of limitation for request for division of estate, and commencement of the statute of limitation. Now we'll move to the content of the case. According to the Statement of Claims dated November 2, 2010, and during the proceedings, the plaintiff's representative being Ms. Kentn 2 presented that Mr. Van K and Ms. Hong TT had 8 children, namely, Kenshin V, Kentn 1, Kentn 2, Kentm 1, Kent T1, Kent H, Kenshin T, Van S, who passed away in 2008, his wife was Nguyen Tm, and his children were Kentui L and Hong K. In 1972, Ms. T passed away. In 1973, Mr. K married Ms. Nguyen TL and they had 4 children, namely, Kent C, Kentm 2, Kenon C and Kent T2. While alive, Mr. K and Ms. T had a land area of 612 square meters, on which there were 2 3-room houses located in T Hamlet, P Commune, TH Town, Hanoi, under a certificate of land use rights granted in 2012 in the name of Mr. Van K. After Ms. T passed away, the aforementioned land and house were under the management of Mr. K and Ms. L. In 2002, Mr. K passed away and those assets were managed by Ms. L and Mr. Kenon C. Mr. K and Ms. T passed away without leaving any will. Then the co-heirs being Mr. K's and Ms. T's children submitted a request to divide the common property of Ms. T and the estate of Mr. K in accordance with the law. Ms. N1, Ms. N2, Ms. M1, Ms. T1, Ms. H, Mr. T, Ms. C and Ms. Nguyen TM, who was Mr. S's wife, requested that their part of inheritance be transferred to Mr. V to use as a place for ancestor worship. One of the defendants, Ms. L, acknowledged that before getting married to Mr. K had assets being the 3-room level 4 house, and 3 kitchens on the land area of 612 square meters. During the use and management of these assets, she and Mr. K improved and rebuilt some ancillary construction works and walls. In 2002, the state authority granted the certificate on land use rights in the name of Mr. Can Van K. At that time, the household of Mr. K consisted of Mr. K, Ms. L, Mr. T, Ms. M2, Ms. T2, and Mr. C. With respect to the claims of the plaintiffs, Ms. L and Mr. C requested that the dispute be settled in accordance with regulations of the law. In the first instance judgment, the People's Court of Hanoi ruled to accept the requests of Mr. Can Shin V, Ms. Can Tn1, Ms. Can T1, Ms. Can Th, Mr. Can Shin T, Ms. Can Tn2, and Ms. Can Tm1. Specifically, determining that the common property consisting of a level 4 house, worship house, kitchen, brick courtyard, walls, cement shed, bathhouse, stainless steel water tank, and walls on the land area of 612 square meters in T Hamlet, P Commune, Th Town, Hanoi had the value of 1,565,504,366 VND, in which the total value of the property of Mr. K and Ms. T was 1,536,331,972 VND. The value of the property of Mr. K and Ms. L was 21,338,977 VND, and the value of the property developed by Mr. C and Ms. H was 7,833,417 VND. Ms. T passed away in 1972. The common property of Ms. T was divided among her children being Mr. V, Ms. N2, Ms. T1, Ms. H, Mr. T, Ms. N1, Ms. M1 and Mr. S. Each of them was entitled to 96,020,748 VND. Mr. K passed away in 2002. The first class in the line of succession of Mr. K are Mr. V, Ms. N2, Ms. T, Ms. H, Mr. T, Ms. N1, Ms. M1 and Mr. S, Ms. L, Mr. C, Ms. C, Ms. M2 and Ms. T2. Each of them was entitled to 30,365,575 VND. The court also ruled to accept the consent of Ms. N2, Ms. N1, Ms. T1, Ms. H, Mr. T, Ms. C, Ms. M1 and Ms. Nguyen TM of their parts of the inheritance to Mr. V, and accept Ms. M2's consent to give her part of the inheritance to Mr. C. About the division of particular assets. Assign Mr. Can Shin V the ownership of assets accounting for 1,041,456,000 VND. Assign Ms. Nguyen TL, Mr. Can C and his wife, Ms. Can TM2, Ms. Can T2 to own assets accounting for the total value of 623,080,710 VND. Aside from that, Ms. L and Mr. C were obliged to pay Ms. T2. Furthermore, Ms. L must build herself a door and a path on her land. As a result, on August 13, 2012, Ms. L and Mr. C submitted an appeal. In the appellate civil judgment, the Appellate Court of Supreme People's Court in Hanoi ruled to accept the appeal of the defendants and to amend the first instance judgment. To accept part of the requests by Mr. Can Shin V, Ms. Can Tn1, Ms. Can T1, Ms. Can Th, Mr. Can Shin T, Ms. Can Tn2 and Ms. Can Tm1. To accept the consent of Ms. N2, Ms. N1, Ms. T1, Ms. H, Mr. T, Ms. C, Ms. M1 and Ms. Nguyen TM to transfer assets to Mr. V. To accept the consent of Ms. M2 to give assets to Mr. C. The assets are divided as follows. Assign Mr. Can Shin V the land area having the worship house split by a straight line crossing the land lot. The total land area that Mr. V was given was 218.2 square meters, valued at 545,500,000 VND, and other assets attached to the land include the worship house and the area of the front porch, kitchen, bathhouse, stainless steel tank. The total value of the assets attached to the land was 15,489,571 VND. Assign the entire land area of 393.8 square meters and the entire remaining assets attached to the land to Ms. Nguyen TL and Mr. Can C to own and use. Ms. L and Mr. C shall pay Ms. Can T2 the value of her part of the inheritance being 30,365,575 VND. Ms. Nguyen TL and Mr. Can C had to open a new path to the common lane of the village. After the appellate hearing, on April 5, 2014, the plaintiffs requested that cassation procedures be conducted as to the aforementioned appellate civil judgment. In Decision Number 73/2016/KNDS, the Chief Justice of the Supreme People's Court protested against appellate civil judgment and requested the Judicial Council of the Supreme People's Court to conduct the cassation procedures to set aside the aforesaid appellate civil judgment in its entirety and set aside First Instance Judgment Number 30/2012/DSST of the People's Court of Hanoi, transfer the case to the People's Court of Hanoi to conduct the first instance procedures. At the cassation hearing, the representative of the Supreme People's Procuracy agreed with the protest by the Chief Justice of the Supreme People's Court. Here are the findings of the court. At the time the plaintiffs initiated the lawsuit, Mr. K and Mr. Van S had died. The heirs of Mr. K and Mr. S were entitled to the parts of the inheritance to which Mr. K and Mr. S were entitled. The first instance court determined that at the time of the initiation of the lawsuit, the statute of limitation for division of the estate of Ms. T had expired. However, the first instance court determined that Ms. T's estate was the common property that was not yet divided and ruled to divide it among the 8 children of Ms. T, which was incorrect pursuant to point A, subsection 2.4 of section 2, part 1 of resolution number 02/2004/NQHDTP. It was correct when the appellate court determined that the statute of limitation for initiating a lawsuit on inheritance from Ms. T and rejected the plaintiff's requests for division of Ms. T's estate. It was, however, wrong when the appellate court ruled that the co-heirs currently managing the estate, being Ms. L and Mr. C, can continue managing, using, and owning it. According to Article 688.1d of the Civil Code 2015, with respect to civil transactions established before the effective date of this civil code, the statute of limitation shall be subject to regulations of this code. Pursuant to Article 36.4 of the Ordinance on Inheritance dated August 30, 1990, and the Civil Code 2015, in this case, the statute of limitation for initiating a lawsuit for division of the estate of Ms. T to the co-heirs had not expired. On the other hand, as per the wish of the plaintiffs as shown in the testimonies, the plaintiffs requested the court to divide their parents' estate in accordance with the law, because they were women who were married, and therefore, they are willing to assign their parts of the inheritance to which they are entitled from their parents to Mr. V to use a place for ancestor worship. Mr. Can T, in his testimony, requested the court to divide his parents' estate in accordance with the law so that he and his siblings would use their inheritance for ancestor worship. Ms. Nguyen T.M. requested that she and her children would assign to Mr. V for ancestor worship the part of the inheritance to which her husband and their father was entitled. However, during the dispute settlement process, the first instance and appellate courts accepted the consent of the plaintiffs in assigning the property to Mr. V was incorrect with the intentions to the involved parties. In light of the aforementioned reasons, the court ruled to accept protest number 73/2016/KNDS, dated June 15, 2016, of the Chief Justice of the Supreme People's Court against appellate civil judgment number 106/2013/DSPT, dated June 17, 2013, of the Appellate Court of the Supreme People's Court in Hanoi. To set aside the aforesaid appellate civil judgment in first instance judgment number 30/2012/DSST, dated July 20, 2012, of the People's Court of Hanoi in their entirety regarding the case on dispute on division of estate and division of common property between the plaintiffs, being Mr. Can V, Ms. Can T1, Ms. Can T1, Ms. Can TH, Mr. Can T, Ms. Can TN2, Ms. Can TM1, against the defendants, being Ms. Nguyen T L and Mr. Can C, and persons with related rights and obligations. To transfer the case to the People's Court of Hanoi for first instance hearing in accordance with the law. Lastly, here are the contents of the case law. Pursuant to Article 623.1 of the Civil Code 2015, the statute of limitation for heirs to request division of the estate is 30 years as from the commencement of inheritance with respect to a movable property. According to Article 688.1d of the Civil Code 2015, with respect to civil transactions established before the effective date of this civil code, the statute of limitation shall be subject to regulations of this code. Therefore, as from the effective date of the Civil Code 2015, courts apply Article 623 of the Civil Code 2015 to determine the statute of limitation with respect to cases of commencement of inheritance before January 1, 2017. Pursuant to Article 36.4 of the Ordinance on Inheritance dated August 30, 1990, and the Civil Code 2015, in this case, the statute of limitation for initiating a lawsuit for division of the estate of Ms. T to the co-heirs had not expired. And that's the end of this video. Thank you for watching, and we'll see you again on the next episode of Learning Legal English through Case Laws.